Good afternoon to all of you. I've spoken to many of you before about this healthcare case, and what I've often boiled it down to is that the litigation is about liberty, not healthcare. And on the healthcare policy today, our side mostly lost. The biggest impact on states, the Medicaid piece, so-called Medicaid piece, is in fact positive for the states in terms of options. On the liberty side, we won. There were 5 votes today, and it was a holding that the Commerce Clause does not allow the federal government to compel Americans to buy a product. That was a holding of the case. It was a necessary holding before they got to the upholding of the penalty for the failure to buy the government-approved health insurance. Our initial reaction upon hearing the result was frankly more negative than now that we've had some time to spend with the opinions, plural. There are numerous opinions. And having spent that time, and we have more time to spend later on, it is not, for those of us whose first priority is the preservation of the Constitution, a bad day at all. For the first time in 85 years, 2 things happened. First, the Supreme Court for the first time declared explicitly the outer limits of federal power under the Commerce Clause. That has never happened since the New Deal, and that is a win for liberty today. We're very happy to see that. The court essentially adopted our economic activity versus inactivity distinction. The Chief Justice wrote the main opinion of the court. I want to share 2 quotes from his opinion with you. The first is on page 24 of his opinion. It said, "The framers gave Congress the power to regulate commerce, not to compel it. And for over 200 years, both our decisions and Congress's actions have reflected that understanding. There is no reason to depart from that understanding today." And they did not depart from that understanding. That was the central thesis of Virginia's case. Later on, page 26, he went on to say that everyone will likely participate in the markets for food, clothing, transportation, shelter, or energy. That does not authorize Congress to direct them to purchase particular products in those or other markets. The Commerce Clause is not a general license to regulate an individual from cradle to grave, simply because he will predictably engage in particular transactions. Any police power to regulate individuals as such, meaning as individuals, as opposed to their activities, remains vested in the states. That is a critically important containment of federal power that has never happened since the New Deal. And I mentioned there were 2 areas where liberty prevailed and frankly made headway. That was one, and the Commerce Clause was the biggest and most important. For the first time in 85 years also, the Supreme Court restricted the Congress and President's ability to use the spending power to compel state action using federal dollars. What we have called the Medicaid coercion part of this case, and remember there were 4 arguments, and during oral argument, 4 distinctive scheduled arguments. The last one was whether Congress could compel states with the threat of taking all their Medicaid funding to expand Medicaid dramatically. And that was a convenient way to talk about what was happening. But what in fact happened in the bill is that Congress created a new program. They continued to use the word Medicaid, but it was separate from Medicaid. And what they did was say if the states won't participate in this, and the rough cost of Virginia would be $200 million a year over the next 10 years on average, using the federal cost estimates. If we didn't participate in that and pony up that additional money and give up transportation and education dollars to do it, then they would take away all of the billions of dollars in Medicaid funding that Virginia gets from the federal government. And what the court said today, for the first time since the New Deal, limiting the spending power of Congress was that Congress cannot use that tool to compel states to spend more dollars. That is the first time that the court has put limits on its ability to use spending power to compel the states to act. So those two brand new restrictions on the federal government are embedded in the court's opinion today. So how did they uphold the act? They upheld the act by finding the penalty to be the constitutional equivalent of a tax. And for those of you following the case closely, you may remember that the first thing argued in oral argument was about an 1867 law called the Anti-Injunction Act that said you can't sue on a tax until you've paid it. Well, the court said the Anti-Injunction Act didn't apply because it is a form of the waiver of sovereign immunity. You can only sue the sovereign, be it the Commonwealth of Virginia or the United States government, if they let you under legislation, with exceptions for violations of individual rights and so forth. And the Anti-Injunction Act is a limited waiver of sovereign immunity. And because the health care bill had other things denominated as taxes in it, but they called this item a penalty, the court concluded that Congress intended to sidestep the Anti-Injunction Act for purposes of the penalty and to waive sovereign immunity for purposes of going forward in a lawsuit such as the one they issued an order in today. That's a complicated way to get there, but what they ultimately did was allow for this penalty to be considered a constitutional tax and therefore upheld the whole statute. So they never reached the severability questions because they upheld the statute under the taxing authority. Now what this means, this is also, it doesn't knock this bill out. And candidly, I had hoped to see this bill fall in its entirety. That's no surprise to any of you. However, in the future, no congressman, no senator, and no president will be able to say for any bill that has the possibility of raising money that it's not a tax. And the taxing power, as the court noted in its opinion, has been the most reliable form of accountability with the American people. There's a reason they didn't want to call it a tax, because they all wanted to avoid being accused of voting to raise taxes. And in fact, what the court said today is that's exactly what they did, even while they lied to us about what they were doing. That's how we got there. Now let me tell you some of the votes. That holding, upholding the health care law under the taxing power, was a 5-4 holding. Chief Justice Roberts wrote that opinion, joined by Justices Kagan, Sotomayor, Breyer, and Ginsburg. The holding that the federal government may not compel us into commerce in order to regulate us under the Commerce Clause was also a 5-4 holding, and that holding was the Chief Justice, Justice Scalia, Kennedy, Alito, and Thomas. And the third critical holding related to the compulsion of states to spend dollars was a 7-2 holding, interestingly, that the states can't be compelled or threatened with the taking away of all their Medicaid funds if they don't join this new, what amounts to an expansion of that program. That was a 7-2 holding limiting the federal government's spending power. And the 7 justices there were the Chief Justice, well, I'll tell you the 2 that weren't. Ginsburg and Sotomayor dissented from that holding. Otherwise, all 7 other justices joined in that holding. We have already started talking with the governor's office. We have more to talk about with the governor's office in consultations as they make decisions about how to proceed. But now we must squarely face questions like, should Virginia undertake an exchange? Should Virginia, and what would it look like if we do? And whether we should enter this new program where we had up to today been threatened with the complete removal of billions of dollars of Medicaid funding if we did not join in that effort. And given the extraordinary expense to Virginia, there are going to be very good reasons why Virginia might consider not going down that road. 200 million of those reasons per year, to be specific, and what that would do to the rest of our budget. Additionally, we are now going to look more closely at an issue that has been held in reserve until today, and that is the question of whether, if we do not set up exchanges, are Virginia businesses subject to the $2,000 and $3,000 penalties per employee? There is significant question as to whether those penalties would properly apply if we do not have a state exchange. And so there may be an additional reason for the private sector for us not to enter into one of the exchanges under this legal structure, under the Affordable Care Act. We may want to do our own for other reasons, but it might be completely separate. And we'll want to hear, of course, and I'm sure our legislators and the governor will want to hear from the business community that will bear the brunt of those penalties in the event that we do not, or that we do set up such an exchange and they choose to put their employees in that exchange rather than provide for the insurance. One other element that comes out of today's ruling, and it, especially in a presidential election year, cannot be overlooked, and that is the critical role that voters are going to play, even more so than in the past, in ensuring that their liberties are preserved. It has been the case historically that legislators are most scared of voting for tax increases. And the Supreme Court today quarantined all of the authority that Congress and the federal government has into that taxing power. The part of the Constitution where legislators and presidents are most scared to tread, and for good electoral reasons. So accountability in many respects, and the future will show, but based on the history of this country, I expect the greater level of accountability that is now going to be imposed on legislators who might try a similar scheme in other areas of the economy. They will have rather short electoral lives. We already saw the consequences of this vote in 2010 for so many in the House of Representatives and the U.S. Senate. There's no question that this will elevate the question of repeal and what to keep and what to get rid of in all of the federal elections this year, President, U.S. Senate here in Virginia, and our congressional races. And voters are going to have a significant role to play, as the founders always intended, is in providing ultimate accountability. So to recap, most of the federal health care bill still stands. However, that portion that was declared unconstitutional is that portion that would force states to forfeit all of their Medicaid funding that exists today if they do not go down the road laid out in the federal health care bill to expanding the Medicaid program dramatically by hundreds of millions of dollars with hundreds of thousands in Virginia of new participants. That part of the bill fell today. But the interest in liberty that were the primary motivation, and many of you have heard me say that 100 years from now what matters is whether or not your government can compel you to buy a product under the guise of regulating commerce. And today, for the first time in U.S. history, the Supreme Court said the answer to that question is no. It cannot. And so individual liberty has been substantial. Was undoubtedly whether the bill stands or falls or how much of it. Our first measure was a constitutional measure. I'm an attorney general. I'm not a legislator any longer. And my first concern is preserving the Constitution and the individual liberty of Virginia citizens. And that was achieved today. It was achieved today. Expensively from a policy standpoint, with a bill that is developing all sorts of other problems, goes forward, nonetheless, we have succeeded in preserving individual liberty, even if we have not won the policy battle in court by knocking this bill out. But frankly, policy battles better belong in legislatures and before electorates anyway.